some of the duties, the duty to retain disputed funds, unless you reasonably believe the claim is invalid. That's actually a little, I think, an improvement. Unearned fees and advanced expenses, be sure to look at that because of the new language on deposits in client trust accounts. Okay, prohibited transactions are Rule 108. Let's talk about that a little bit. Rule 108A is the traditional one that says, thou shalt not enter into a transaction with a client that's not fair and reasonable to the client. Then watered down a little bit in this proposal, it would say you only need to reasonably believe that the terms are fair and reasonable. And that's got some criticism from that.
Well, so let me intervene right there. In saying that the lawyer, the standard that's written in these rules is that the lawyer reasonably believes that the transaction is fair and reasonable. That's not what the existing standard is, but the problem with that is that the fiduciary standard in a breach of fiduciary duty case is that a transaction between a lawyer and a client has to be fair and reasonable. So it's not whether the lawyer thinks it is, it's whether an independent, a fact decider fact-minded will decide whether or not it's fair and reasonable. But these rules talk in terms of that it's just the lawyer needs to believe that it's fair and reasonable.
Yeah, you see, past, you need to be aware that it's a trap for the unwary. Don't assume this is the real standard you're going to be held to.
But I mean, this is really serious because if you start relying on these and think, I'm safe as long as I do this, and then the same thing applies in 108. Maybe you've got something with respect to arbitration. Do you have the arbitration?
Yeah, you get the arbitration. Yeah.
What do you get?
But the second requirement is that the client must provide informed consent. This one is writing something opposed to the other complex rules to the terms of the lawyer's role. And then third, you have to advise the client more or less at the present of the desirability of getting independent counsel. But then, what about cases that are modified? 108A comment 3 says that it doesn't apply to ordinary cases. Those standards in 108 apply to ordinary cases, but they may apply to modified cases. Well, that's interesting. Well, they don't say. What they say is it typically will apply if your fee includes an interest in the client's business or other non-monetary property, but it doesn't say when else it will apply. So that's just unknown. 108B, how much time on that's the gift. It is different. That's the gift from a. The interesting thing is it apparently now will permit the gifts in a life partner setting. So that's actually both a broadening of the rule and a surprise from the Republican Supreme Court. Okay, now this is one the insurance defense lawyers have complained about. When a third person, this is 108, E I guess it is, 108, which says when a third person pays the fee, as you know, there are certain requirements that apply. Now you must obtain the informed consent of the client. Remember, informed consent has those two elements. Explain all material risks and all reasonably available alternatives. So you have to explain all the risks to the client. Interestingly, that applies in insurance defense setting. The comment says, and comment 15 is a trap for the unwary. It says, normally the client has consented in the insurance contract to the hiring of insurance defense counsel. Well, that's true. You read your insurance contract, which all of you read. It only has consent, but what it doesn't have is informed consent. Because you've never had your insurance contract explained to you by a lawyer who explained all material risks and reasonably available alternatives. Never happened to you in your life. It won't ever happen to anyone, except if this rule goes into place. What do you as insurance defense counsel have to tell every one of the insurers you represent? I guess we'll find out. 108G is the one, actually we're about out of time, so let me move down to 108G2. Do read 108G, which has been in the news. That's the one that raises the question of whether you can settle grievances and professional misconduct. And there was a change that came out of the bar board to try to address that. Some people think it's still unclear as to whether you can or cannot do that based on the current language and the comment. But let's turn to binding arbitration, which Eamon wants to talk about, and It permits binding arbitration if certain requirements apply. Those requirements, bottom line, are different than the December 2008 ethics opinion that came out that said what you have to do in order to obtain binding consent to binding arbitration of part of client.
Which was extensive disclosure with a lot of detail about that. In this rule, either the client has to be represented by independent counsel, or the lawyer discloses in a manner that can be reasonably understood by the client. Usually, this time the client has to understand it for the lawyer. The scope of the issues, and the fact that the client will waive a trial before a judge or jury on these issues, and that the right of appeal may be limited. Now, do you think the right of appeal is going to be limited in an arbitration case? I mean, I'm worried about fiduciary breaches there. I mean, the chances of being able to appeal an arbitration are so remote from a practical standpoint that just telling the client that is risky.
And comment 19 has other proposed disclosures you should consider. And then you may want to compare it back to opinion 586, which had other things that should be disclosed. And if you talk to an arbitrator, and you ask yourself, if somebody came into me and said they're about to enter into binding arbitration with another lawyer, they're thinking about it, should they do it or not? Wouldn't you say yes? I'd say yeah. Bernie Madoff maybe, but when would you advise a client to give up all the rights you would give up? I agree to just arbitrate before you give up the trial, I'll let you read both the trial, and all that.
Ask questions. What questions do you have?
What questions do you have in 45 seconds? Yes.
What about the proposed changes to the rule that address discussions with the state agency before a case gets filed?
Yeah, I wish we had time. We were actually dealing with that this morning. That was going to be the next one we talked about. That's Rule 3.05. And in essence, the issue was this. We currently have a provision in Rule 3.05 that defines pending matter to include when it's reasonably foreseeable that a matter will be assigned to a tribunal. And that means if I'm coal company out of Wyoming and I know I'm going to try to go to TCEQ and get a permit application, I know they're going to decide it. I can't go the day before and have an ex parte conversation with the commissioners. Just like you can't go, if you're going to file a lawsuit tomorrow and talk to the Judge Deeds if you want to. But that same kind of principle applies, reasonably foreseeable. That was removed by the Supreme Court, has been reinserted after a lot of objections by the Supreme Court, but there's been a new comment added to the rule that is now being debated as to what that means and whether you'll be able to do it or not, because the comment refers to matters allowed by state law. And without getting into the minutia, the Vandy Grift decision, which is what the administrative lawyers have relied upon before this ethics opinion came out, that said you can't do it. There's some question as to whether that comment throws them back in the Vandy Grift. But Sierra Club, Environmental Defense, lots of citizen groups hate this proposed change that the Supreme Court seemed to have eliminated, but it may be coming in the back door through that comment. So that's still up in the air as far as I know. Okay, thank you so much for your time, and we encourage you